let's turn it over to an expert. I can think of nobody better than Alan Dershowitz, of course, Harvard Law professor and defense attorney. Hello, Mr. Dershowitz. How are you, sir?
Hi, very good. In fact, I wrote a book on precisely that subject about 4 or 5 years ago entitled, Is There a Right to Remain Silent? And though I'm a liberal Democrat, the Republican congressman is absolutely correct. You can't simply make statements about a subject and then plead the fifth in response to questions about the very same subject. Once you open the door to an area of inquiry, you have waived your Fifth Amendment right. Now, what she'll say, or her lawyers will say, is, well, she didn't say anything incriminating in her opening statement. Now they're asking her to make incriminating statements, so she has the right to remain silent. That's not the way it works. That's not the way it works. Once you open up a subject matter of inquiry by your own testimony, then you've waived your self-incrimination right on that subject matter.
Wow.
So she's in trouble.
Wow.
She can be held in contempt. Congress has this very strange procedure. They never use it, but they can actually hold you in contempt and put you in the congressional jail. There's a little jail nobody knows about on the bottom of Congress and keep you there. What they generally do is refer the case to the U.S. Attorney's Office. Now, of course, the U.S. Attorney's Office, the U.S. Attorney's Democrat in the District of Columbia. So we'll see whether there is a prosecution for contempt. But it seems to me it's an open and shut case that she's waived her Fifth Amendment privilege.
So they call her back. She comes back, if she does come back, and then pleads the Fifth, or doesn't come back and says, I already plead.
She has to.
She does.
Back.
Okay, so she says, I plead. She takes the Fifth, no matter what they say to her when she comes back.
So here's the way they have to do it if they're smart. They have to ask her a question. They have to start by saying, you said on your direct the following. Let me follow up and ask you this question. She then, if it's within the zone of what she testified to, she's waived her Fifth Amendment privilege. If it's an entirely different area, which it won't be, it'll be the same area, then perhaps she hasn't waived her Fifth Amendment. But if they say, you said this, now we want to follow up. Did you mean this, or how do you respond to this? And if it's in the same area, she has no Fifth Amendment right. She's waived it. She can be held in contempt for refusing to testify.
Well, now, now I'll ask you to speculate. How does she, from what I understand, an attorney, sitting next to an attorney, how does they pre-plan to come in and give an opening statement and allow this to happen?
It's malpractice. It should never have been allowed. She should have been told by her attorney that the law is clear, that once you open up an area of inquiry for interrogation, you have to respond. Now, she may have made a political decision that it's worth it to take the risk and to take the chance. She wanted to get her story out there, and she didn't want to respond to questions on cross. That's just not the way the law works. It may be the way politics works, and it may be that a political decision here trumps the legal niceties because we're, after all, dealing with Congress, which is a political body. But she can't invoke the Fifth. This goes back to the bad old days of McCarthyism, where the House Un-American Activities Committee and the Senate committees tried to trap people by saying, look, you're a Fifth Amendment communist, you won't answer any questions. And the people were saying, we'd love to answer your questions, but we can't, because if we do, we've waived, and then you'll ask us who our friends are and who else was a member of the Communist Party or who we knew were members of the Communist Party. So all the case law was developed in the late 1940s and 1950s by the Supreme Court. But the law is as clear as could be, that once you open up an area of inquiry, you can't shut off the spigot. I think that's the metaphor that the Supreme Court has used. Once you turn on the faucet, you can't turn it off when you choose to. It goes area by area, subject matter by subject matter.
All right, very, very interesting, and it'll be fun and to watch and see how this does play out. We're talking Alan Dershowitz here on the Steve Malzberg Show. Let me ask you about the one of the other scandals, and that is the Justice Department going after the media. The New York Times weighed in on that today, calling the title of their editorial "Another Chilling Leak Investigation," referring to James Rosen, the chief Washington Washington correspondent for Fox News. Back in '09, they obtained a subpoena where they called him a co-conspirator in trying to track down a leak on an incident involving North Korea. The editorial starts with the decision to label a Fox News TV reporter a possible co-conspirator in a criminal investigation of a news leak. The Obama administration has moved beyond protecting government secrets to threatening fundamental freedoms of the press to gather news. Agree?
No. It's a much more complicated and much more delicate issue. The press has no right to publish classified material. The problem is the government encourages the press to publish classified material all the time. When somebody like Seymour Hirsch, writes in the New Yorker, he's given classified material to publish, and he publishes it. When Bob Woodward interviews people in the White House and publishes classified material, the government encourages it. They pick and choose what classified material they want out there. The law is far too vague in general. The statute doesn't permit the New York Times to publish classified material, but the New York Times publishes it all the time. They publish material about the National Security Agency's use of electronic overhearing that really hurt our national security. But they published it. Nobody's going after the New York Times. Now, the question is, when you start going after Fox, after what the IRS we know did, it really begins to look very suspicious and very selective. And what I've written articles about this, you have to either do it across the board and go after everybody, the New York Times, the Washington Post, everybody who publishes classified material, or you can't go after anybody. But you can't have one law for Fox and one law for CNN. You can't have one law for the New York Times and one law for Julian Assange, who is somebody I've advised legally. There has to be one law for everybody. And that's not what's going on today in the Justice Department. But it's very, very complicated. People should not be leaking classified information about who our terrorist targets are in Yemen or what's going on in North Korea. There is room for national security secrets. And the New York Times shouldn't be publishing national security secrets in general, but we have to have one law for everybody.
Right, agreed. But this is, from what everybody is saying, is unprecedented. They've charged Kim. He's pleaded not guilty. He was the subject of the investigation along with co-conspirator Rosen, apparently. How is a reporter speaking to an official who might be leaking information? Isn't that the reporter's job? And if it's not, then if as you say, they shouldn't be publishing this, isn't it, as has always been done, doesn't the Justice Department or someone go to the reporter or the organization and try to cut a deal before they subpoena these personal records?
Generally, that's what happens. But it is today against the law for the New York Times to publish classified material. And as you know, they went after the New York Times in the Pentagon Papers case. And eventually the Supreme Court said, you can't stop them from publishing it in advance, but you can prosecute them after the fact for publishing it. Now, they chose not to. But the law on this today is very unclear. The Justice Department has its own policies not going after journalists unless it's an extreme case. And they can't be doing it based on whether it's Fox or whether it's CNN, whether it's somebody they like or somebody they don't like. That violates.
Well, they should love the AP. I mean, the AP's friendly to that administration.
Well, the AP is pretty neutral.
Well,
AP,
we can debate that.
I don't think they have a political point of view the way Fox or maybe MSNBC does. But they shouldn't be doing this. Look, there was also an op-ed in 2 days ago's New York Times written by 4 former attorney generals and deputy attorney generals saying how complicated this is and how difficult it makes the life of the Justice Department when there are these kinds of leaks. There are genuine national security secrets. You might be surprised to hear this from a liberal who believes in the First Amendment, but there are things that the newspapers shouldn't publish. We shouldn't be publishing the names of spies. We shouldn't be publishing the names of targets. We shouldn't be publishing information that make it hard to defend the national defense.
No, I agree. It's just that if it's never been done this way to prevent those leaks, then there's got to be a better way.
Looks terrible. For the administration to be going after the Tea Party with the IRS, Fox, that's the other case. The Saudi Arabian case is Fox. AP is a little different, as you said. But they can't be picking and choosing.
Well, Fox is North Korea. Yeah, Fox is North Korea.
That just doesn't make any sense.
All right, let's change one more for you if you can, and that is Jodi Arias. She gave an incredible presentation, slideshow and all. Today, the jury came back deadlocked in the death penalty phase. The judge sent them back to try to agree. I got to feel if they're deadlocked, they're not going to all agree on death. But that aside, what did you make of her, basically asking for life as opposed to death, because in prison she could do a recycling campaign, she could do a literacy campaign, she could donate her hair to charity.
Look, we know that people who've done terrible, terrible things have done good things in prison. Take a look at the weathermen, who are now being glorified in a film. And
well, you and I talked about that, and that started a firestorm.
Yeah. So, people can do things. Remember Leopold and Loeb, those terrible thrill killers in the 1920s? When Leopold went to jail, he helped cure various malaria and various diseases. He was a great medical researcher. He allowed his body to be used. It's not the strongest argument in the world against the death penalty, but, as a long-term opponent of the death penalty, I hope that she persuades at least some jurors not to convict. All you need is one juror.
Right, I think she has that,
it, and I suspect she's going to prevail on that.
All right. Listen, Alan, thank you as always for your time. You were very generous. Thank you.
Thank you.
Bye-bye. Alan Dershowitz, ladies and gentlemen, here on the Steve Malzberg Show.